Hi guys, I am Ayushi, your mentor for law entrance exams, and welcome to Law Digest. This is the second video of our revision series on IPR law. इस series में हम revise करने वाले हैं patent law. Before this, we have already revised copyright law. If you want to check that video, you can go to the playlist section and check the IPR law playlist where you will get the first video. And just in case you want to stay tuned and want more such videos, what you can do is you can subscribe to this channel and press the bell icon. Let's start with the first question. The first question is, what is the law relating to patents contained in? So the law of patents contained in which law? In the copyright video, you will see that the first question was this only, that the law relating to copyrights law is contained in. I'll not tell the answer, you mention the same in the comment box below. Now, law relating to patents is contained in which of the following acts? Patent Act 2002, 1995, 1970 or 2005. The correct answer here is option C, that is 1970. These are the years in which the Patent Act was further amended. The basic law is contained in the Patents Act 1970. Moving on to the next question. प्रोडक्ट पेटेंट वॉज इंट्रोड्यूस्ड इन विच ऑफ द फॉलोइंग ईयर्स? इससे पहले वाली स्लाइड में अभी हमने देखा दैट पेटेंट एक्ट जो है वो 1970 का है. उसके बाद से अमेंडमेंट्स आती रही हैं. सिंस 1970 देयर हैव बीन सर्टेन अमेंडमेंट्स एंड प्रोडक्ट पेटेंट वाज इंट्रोड्यूस्ड थ्रू एन अमेंडमेंट ओनली. नाउ दैट अमेंडमेंट हैपेंड इन द ईयर 2005. ऑप्शन सी इज द करेक्ट आंसर. अर्लियर व्हाट यूज्ड टू हैपन वाज ओनली द प्रोसेस थ्रू व्हिच अ प्रोडक्ट हैज बीन मेड. सो इट वाज सेड दैट इफ देयर इज एनी medical product or a chemical product, so the process through which it has gone, that process only could have been patented, not the product itself. But in 2005 the product patent was introduced and now our Patent Act was in compliance with the TRIPS agreement. So TRIPS agreement is an agreement which is applicable worldwide to the parties who are a part of it. So this is basically relating to your trade related intellectual properties. So by introduction of product patent, we were in compliance of all the terms of the TRIPS agreement. Moving on to the next question. What is the term of the patent once granted? So patent का क्या term होता है? 10 years, 20 years, 30 years or 40 years? The correct answer to this question is option B, that is 20 years. A patent can be granted for a period of 20 years only, unlike copyright which continues till the lifetime of the author and also beyond that. Now, which of the following is patentable? इनमें से कौन सी चीज पेटेंट करी जा सकती है? Process, product, invention, or all of the above. So like we saw in the questions before this, process is obviously patentable. Since 2002 it was there. Now product patent was introduced in 2005. So here we can see ये दोनों तो patentable है. So therefore option, the answer जो होना चाहिए वो all of the above होना चाहिए, even if we go by the exclusion method. And invention is also patentable. Therefore option D is the correct answer to this question. Moving on to the next question. The conditions of patentability include the following. So what are the conditions of patentability? When can something be patented? Novelty. Novelty means that something is new. कोई नई चीज बन के आई है. Then second is inventive step. कुछ inventive step है, कुछ obvious नहीं है. There's not anything obvious. जैसे कि आपने अगर ice cube को उठा के sunlight में रख दिया तो obviously it will melt. There is nothing new in it. You cannot say that this is an invention that is made by me. That is an obvious thing that will happen. That's nothing non-obvious. So before granting a patent, the step should be an inventive step. Then it should be applicable industrially. So utility होनी चाहिए product की, it should be applicable. So therefore option D is the correct answer here, that all of the conditions are there that are required so that a patent can be granted. Then next is, which of the following do not form an invention? इसमें से कौन सी चीज invention नहीं मानी जा सकती? कोई frivolous invention है, Obviously, something that is frivolous cannot form an invention, cannot be patented. Then mere discovery of a scientific principle is also not an invention. Then a method of agriculture or horticulture is also not invention. So all these three things are not inventions. Option D is the correct answer here. There are a list of many things that have been put under this category, that's something that cannot form an invention. So there's a whole list, you can look it up through Google or whatever material you are referring to. Then next is, at what stage can granting of patent be opposed? So it can happen that you've applied for a patent and your application gets rejected. आपने patent के लिए apply किया है और वो reject भी हो सकता है, जरूरी नहीं है कि हर केस में आपको patent मिल जाएगा. So किस stage पे वो application जो है वो reject करी जा सकती है? When can that application be rejected? Where an application for patent has been published within the period of 30 days, or where an application for a patent has been published but the patent has not been granted. So application has been published but patent has not been granted. At that time there can be an opposition. This is called pre-grant opposition. Before granting the patent, opposition can be there. Then next is, at any time after grant of the patent but before expiry of period of 1 year from the date of publication of the grant of patent. In that case also the granting of patent can be opposed. This is called post grant opposition. So these are the two stages when the patent can be opposed, granting of patent can be opposed. Therefore both B and C is the correct answer to this question. Let's move on. A person may oppose the grant of patent on which of the following grounds? So before this we saw that opposition of grant of patent कब हो सकता है? Pre grant, post grant दोनों हो सकता है. Here we are looking at कि on what grounds can granting of patent be opposed? Obviousness and lack of inventive step. We saw that this is an essential for granting patent. Then non-patentable invention is a ground for refusal. Then insufficient description of the invention is also a ground for opposing the grant of patent. Therefore option D जो है वो इसका correct answer है. Moving on to the next question, which of the following is not a right of the patentee? इनमें से कौन सा patentee का right नहीं है? To exploit the patent, obviously it is the right of patentee that he can exploit the patent. To license or assign the patent to another, that is also a right of the patentee. Only a patentee can do such a thing. Then to surrender the patent, obviously patentee has the right to surrender the patent. Therefore all these three things are a right of the patentee. Therefore none of the above is the correct answer here. Now moving on to the next question. The final question, India became a signatory to the Patent Cooperation Treaty in which year? So it is important for us to know that what were the conventions and with respect to IPR law, and what is the position of India with respect to those treaties. So now India became a signatory to the Patent Convention Treaty in the year 1998. So with this we come to the end of this video. I hope that you could get some clarity on patents. If you are new to IPR law and you're clueless that how should we go about IPR law, where should we study from, resort to the internet, pick up the topics from here, or you can look up our website www.lawdigest.in for more modules on IPR law. And in case you have any further queries on this particular video, you can mention the same in the comment box below.